Okay, if we could get started. So, welcome to this workshop on the new law in Massachusetts related to marijuana. This is one of the workshops that the Berkshire Regional Planning infrequently does on various topics of the day, and we thought that this was a very important topic that will be facing all of our municipalities. So tonight's purpose really is to talk about the law that was amended and recently passed in July by our legislature. In January, earlier this year, we did a similar type workshop, and now this one is really going to focus on some of the changes to the law that will be implemented going forward, or is implemented. We are very lucky to have Ray Miares again give the presentation. He's been very generous with his time along with this. Ray is a town council for a number of towns, and one of them being Stockbridge in Berkshire County. I also want to thank the folks who set up the sound and the cable TV system. It is being recorded on the cable TV network, and I was told that it'll be available next Tuesday for viewing, so there'll be a link to it if you want to take a look at it again, or if you want to let your friends or your other municipal officials know about it. So with that, we're going to kind of move right into it, and I'm going to really turn this over to Ray. It's been his show. He knows the law, and we'll take it from there. I am reminded that if you have questions, that in order for it to be picked up by the recording, you need to speak into a microphone. And there's two of the Berkshire Regional Planning Commission staff, Eamon Coughlin, who's in the back, who has a microphone, and Pat Mullen, who has another microphone. So please wait until they come over to you with a microphone if you have a question. So please welcome Ray Miares as part of the presentation.
Okay, so looks like I've turned up like a bad penny again. 6 months ago, I was here, I guess, in January, and we talked about the marijuana laws as they existed after the adoption of Question 4 at the ballot last November. For those of you who were here to see that, you might recall that pretty much every other sentence I said had something to the effect that I'm guessing what the law means. A lot of other people were also guessing what the law means, and including the legislature, who decided that what it seemed to say and what it meant were not the same. And so the legislature decided to try to rewrite it and produce 75 new pages for us to attempt to interpret. Some questions have now been resolved, and we'll talk about those. Some questions are still not resolved. When you have a brand new statute, it's often the case that that some of the details are not as clear as you were. I promised to keep the number of puns down to a manageable roar. Last time we had a high-level overview. Today we're going to have a less high-level overview. Okay, so what do I do here? I go to the next one like that? No. Use the mouse. And how do I make it go? What do I do? I hit it here. Yeah. Here, right there? Yes. Right. All right, there you are. Okay, so we always start with a disclaimer. Want everybody to understand that I'm not giving out legal advice today. So none of you are my clients, and this is something that I necessarily have to put into every presentation. Okay, so here we have what passes for legislative history. So legislative history is the history of how a law comes into being. And what we have here is a little unusual because we started on November 8th with a referendum question. That referendum question was written by people who do not practice law in Massachusetts. It included a lot of unusual language and terminology that we have not seen in Massachusetts before. It doesn't appear to have been written explicitly for Massachusetts cities and towns, and therefore caused some difficulties. In December, the legislature, in its infinite wisdom, decided to extend all the deadlines that were in the original legislation to give people an opportunity to figure out what the regulations might look like and how they might be impacted. And then on July 28th, we had the big overhaul, which appears in Chapter 55 of the Acts of 2017. That's the one that's 75 pages long. Okay, so the original point of question 4 was that what's shown here, adults can possess and cultivate marijuana in limited amounts. There'll be a regulatory body that's going to be called the Cannabis Control Commission. There's going to be an excise tax and a local option sales tax authorized, and there will be procedures established for regulation of local land use. So that all occurred in question 4. In Chapter 55 of the Acts of 2017, that's the new law. The basic idea, adults can possess and cultivate marijuana in limited amounts, is basically unchanged. A slight increase in the limits of the amount. The Cannabis Control Commission was reconfigured. In the original version, there were 3 members, all appointed by the treasurer. Now we're going to have 5. The excise tax has been jacked up from 3 3/4 to 10 3/4. That's on top of the mass sales tax. So basically, the state's raking in 17% of the sales of whatever marijuana sales there are, and the local municipality has the option of adding 3% more for a total of 20. So, okay, and last but not least, in most dear to our hearts, is we now have an actual process that we can follow for adopting land use regulations. So we'll talk about that. So as before, the state oversight consists of 2 bodies, the Cannabis Control Commission and the Cannabis Advisory Board. The Cannabis Advisory Board last time had 15 members, but now it's exploded and it's got 25. Anybody who's ever served on any kind of a committee knows that 25 is not a good number. But that's the advisory board. The 5 members of the Cannabis Control Commission will be responsible for actually issuing the regulations and also issuing licenses. One thing that's different about the Cannabis Control Commission now from the last version is that they will have regulatory authority over medical marijuana facilities as well. So currently, those are regulated by the Department of Public Health. DPH is going to get out of that business. All of their authority is going to be transferred over to the new commission. There is a provision that says the commission can adopt new regulations for medical marijuana facilities, but they can't be more stringent than what DPH has already done. I would be surprised if the regulations underwent much by way of revision. I would expect them to be lifted more or less wholesale onto the new CCC regulatory program. Okay, so the last time the Cannabis Control Commission had just 3 members, as I mentioned. They were all to be appointed by the treasurer. Now we've got something a little more elaborate. We got one appointed by the governor, one by the treasurer, one by the attorney general, and then two more that are going to be appointed by majority vote of those three. The deadline for appointing these members is tomorrow. In addition to having different people involved in involved in the appointing process, the statute also specifies particular expertise for each and every one of these. So, for example, the governor's appointee is supposed to have a background in public health, mental health, substance abuse, or toxicology. The treasurer's appointee is supposed to have experience in corporate management, finance, or securities, and oh, by the way, will be the chair. And the attorney general's appointee is supposed to have a background in public safety. And then the other two members, one is supposed to have a background in oversight or industry management, including commodities, production, or distribution in a regulatory industry. And last one is supposed to have a background in legal policy or social justice issues related to a regulated industry. My understanding is that the legislature couldn't decide whether to leave the appointment with the treasurer and specify expertise, or to split it up, and so they ended up doing both. So, as I said, the deadline is tomorrow. Oops. There we go. We got two appointments so far. So we still got 3 mystery seats which have not been appointed yet, and presumably we will hear about it tomorrow. I was told specifically that the Attorney General will make her appointment tomorrow, so just in time. The advisory board, I'm not even going to try. Every single one of these 25 people is supposed to have a specific area of expertise. I've got the great long list here, but it's mind-blowing. The important thing is the governor gets 5, the treasurer gets 5, the attorney general gets 5. There's 9 that are specific offices. Each one of those, it's the commissioner of revenue or his designee, the commissioner of agricultural resources or his designee. So the word "or his designee" should appear after each one of those things. And then there's a one mystery one, the registered qualifying patient appointed by the president of the Mass Patient Advocacy Alliance. So for those of you who aren't in on the lingo, registered qualifying patient is a person who has a medical marijuana card. Okay, and so that's what the 25th member. They're supposed to be advising on all aspects of marijuana, but in particular focusing on substance abuse type concerns that may arise from the regulation of marijuana or from the existence of the industry. So we used to have a much more complicated implementation timeline, but it's been streamlined considerably. So on December 15th, last year, individual possession and cultivation became legal. It is still legal. That deadline didn't change. The next deadline that comes up is March 15th of next year. That is the deadline by which the CCC is supposed to issue its regulations. The statute gave them an extra 2 weeks. In the old version, it was March 1st. The one exception is regulations for testing facilities. They get a little more extra time till May 1st. On April 1st of 2018, the CCC begins accepting license applications and will start issuing licenses June 1st of next year. All of the stuff that was in there before about different timelines for different kinds of facilities and whatever has all been removed. So in that sense, this is simpler. So the this slide is exactly the same as one that appeared the last time. The adults may possess and cultivate marijuana starting December 15th, 2016. Public consumption is still prohibited with a fine not to exceed $100. And as I mentioned before, as of December 15th, 2016, anyone in the Commonwealth could go into the building department of any city or town and get a building permit to build a pot shop. There was, on that date, there was no prohibition pretty much anywhere, and the fact that licenses were going to be coming later does not prohibit a entity from getting a building permit. There's lots of building permits that people apply for facilities that aren't yet licensed, and so I was predicting that there would be a run on building permits soon after December 15th, 2016, and I was completely wrong. I'm not really aware that of any building permits that have been applied for anywhere as early as that, but maybe there's one somewhere. Okay, so I would say about 90% of the zoning ordinances and bylaws that I have seen say nothing explicit about marijuana facilities, and that's because they weren't legal. Every once in a while, I have run into a zoning bylaw or ordinance that, in the course of permitting medical marijuana facilities, they added a sentence, and no other kind of marijuana facilities. So there are, in fact, a couple of examples that I've run into where existing zoning bylaws already prohibited these kinds of facilities. But assuming that you don't have something like that in your city or town, here's the rules. A marijuana retail store is a retail store. So anywhere in your zoning where a retail store is permitted, or permitted by special permit, or whatever the rules are that apply to a retail store, they apply to a marijuana retail store as we stand today. A marijuana manufacturing facility is a manufacturing facility. So wherever you allow industrial facilities, manufacturing facilities, they are permitted. The fact that marijuana is what's being manufactured is not relevant. Same thing with testing facilities. A lot of zoning bylaws don't really talk about testing facilities, but some do have something like research and development facilities in there. If they do, a marijuana testing facility is just like any other kind of a testing facility. That rule is not the same for cultivation facilities, and that's because our friends in the legislature last December specifically reached the conclusion that marijuana cultivation is not agriculture. So your zoning bylaws and ordinances all have provisions that say if you're that the agriculture as defined by Chapter 40A, Zoning Act, is protected and is a permitted use in all districts. That's because Chapter 48 prohibits you from prohibiting agriculture uses everywhere. So the legislature quickly clarified that doesn't mean that you are required to permit marijuana cultivation facilities. So it doesn't enjoy the protection of Chapter 40A, Section 3 that other kinds of agriculture do. So then the question is, what is it? I think somebody asked that question in January. I said, I think I said at that time that it probably should be treated the same as any kind of an industrial facility. Today I will give a little bit more sophisticated answer than that. I've seen quite a few zoning bylaws and ordinances that have another provision for agriculture. So they have agriculture protected by Chapter 40A and other agricultural facilities. So the rules that would apply to other agriculture outside of the protection of Chapter 40A is probably what applies to your marijuana cultivation facilities. So one option that all of you have in your cities and towns is you're done. That's the rules. We like those rules. No need to do anything more sophisticated than that if those are the rules that you want. The key is to understand whether those are the rules that you want. Okay. There are three special kinds of limits that in a local ordinance or bylaw that get special attention in the statute. The one that has gotten all the attention is the ones that say that either all marijuana establishments or particular types of marijuana establishments are prohibited. But the statute also talks about limiting the number of marijuana retailers either based on the number of package store licenses or based on the number of medical marijuana treatment facilities. So if you want to do any one of those three things, and a few towns have done the first, and I don't know anybody's done the second or the third, but if you want to do one of those things, then there's special procedures that have to be followed. You might recall, in January, I talked about the great mysterious language in the question 4 that said that something like this required a vote of the voters. There was a lot of debate about what that term means, and we'll never know because the new statute completely wiped that phrase out. And we don't, what we have now is a ballot question, a language that looks more like the kinds of ballot question languages that we see in most general laws. So, what's rather peculiar about the law is that the process that you have is based on whether your city or town voted yes or no on question 4. To my knowledge, this is the first time certainly the first time I've ever seen a statute that tied a legal consequence to a previous vote that the people who were doing that previous vote didn't know about. So at the time that everybody was voting on whether or not to legalize marijuana, they weren't told, because it wasn't true then, that it would make a difference in your town what process you would have to follow if you wanted to limit the number of facilities. But nevertheless, that's what the legislature decided to do. So if you voted yes on question 4, then it will be harder to limit the number of marijuana establishments or to ban them. It will require a ballot question plus a town meeting vote or in the case of a city council vote that's required. If you voted no, it will be easier because you don't have to go and get another ballot. Only the town meeting vote or city council vote is required. If you have been looking on the websites of various people who are active in this game, you might have run across a summary of the law that was prepared by one of the senators who was on the committee that forged the compromise. And on that website, it says that a ballot vote is enough. And after that, the Board of Selectmen or the mayor, I guess, can simply ban retail facilities. I think it says retail facilities, but let's say commercial facilities of all kinds. He says that they can do that. I believe that is wrong, and I'm a little horrified that there were only 6 people on this committee, and one of them, who is a lawyer, has gotten it that wrong. And this is something he wrote. So I'm a little concerned about that, but here we are. So the situation is this. These are the cities and towns and how they voted on question 4. As you can see, there are pockets on the Cape, the sort of ring of suburbs around Boston, not the inner suburbs, but the further out suburbs, a bunch of municipalities around Worcester, pockets of no's. This was not a question that received unanimous approval, except in Berkshire County. Okay, so the voters of Berkshire County did me a favor because I don't have to explain what happens if you voted no. Everybody in Berkshire County voted yes, and so that makes this presentation 5 minutes shorter because we don't have to talk about what happens if you voted no. It turns out, however, that no comes in a lot of different flavors. So if you look at this, you'll see that Dalton voted yes, but with 51%, whereas there are 1, 2, 3, 4, 5, 6 towns that were over 65%. So some people voted yes, and some people voted resoundingly yes. As far as the law is concerned, yes is yes is yes. Doesn't really make any difference. But in the towns that I have been involved in, where they have talked about bans, it's been important to talk about how overwhelmingly for or against the town was. The fact that a town voted yes should not, even though I think the legislature thinks so, should not, in my mind, be interpreted to mean that people were voting to have retail facilities in their own town. They may have just been saying, we think weed should be allowed, and the rest of it is details. So, especially in a town where the vote was close, I think you're going to find a few towns that may be interested in doing bans, notwithstanding the fact that they voted yes on question 4. So for those towns, here's your process. The green circle is me. I have to write, the town council or the city solicitor has to write a summary of the proposed bylaw that will appear on the ballot, plus the entire text of the proposed bylaw has to appear on the ballot. And then there needs to be a majority vote of on the ballot. And then, at least with respect to zoning restrictions, which most of these are, it would still need to go to town meeting or to the city council and get a 2/3 vote. Okay, so the process, if you read the statute carefully, the process seems to assume that this is the order that you're going to go in. You're going to do the ballot question first, and then it's going to go to town meeting or to the city council. That's lunacy. Not to put too fine a point on it. It makes far more sense to go to town meeting or to city council and get your bylaw ordinance passed, and then you know what it is, and it can go on the ballot. If you do it the other way, and then town meeting wants to make a change, even if they change one word, they'll have to go back to a ballot again. So it's nutty to suggest that the ballot question should go first. It can, but you are running a real risk. I talked to the Attorney General's office. Go ahead. Yep. Got a question?
Cold to close. Ooh. A couple of slides ago, you were talking about harder and easier. So
Yes.
do we assume that these votes that you're talking about are to limit or to approve a selling facility?
This is the process for limiting or prohibiting facilities.
So
this
if-
is the harder process.
So if we do nothing,
Right.
then a retail facility can exist.
If you do nothing, a retail facility exists on exactly the same terms as any other retail facility.
So this process then, just to be clear, is only if you want to limit.
That's correct.
Okay.
That's right. If you want to adopt a limit, this is the process that you have to use.
Okay.
So what I was saying before was I talked to the Attorney General's office a couple days ago, and I said, the statute is written as if the ballot question has to go first. Are you going to stick with that? She said, no, she doesn't care. Either order will be fine with her. So that's a good thing. I have a question over here.
Just an observation that the other issue with the order that's presented on the slide is that typically the votes for ballot questions happen a week after town meeting. So if you do it this way, you've basically got a 2-year process.
It's true. It's another example, I'm afraid there are far too many, where the legislature doesn't really understand how local government works. And so, yes, you're absolutely right. If you do it with the ballot question happening a week after town meeting, you might be able to pull this off, but you have to put the question on the ballot back 35 days previously, so you just better hope that the town meeting doesn't mess around with the text.
And in towns where the vote occurs the week before town meeting, if a majority voted to ban, what would happen if the zoning change did not receive a 2/3 vote?
I would say nothing would happen. It would not be adopted. It needs a majority vote at the ballot plus a 2/3 vote if it's a zoning bylaw at town meeting. So you've been very patient over here.
If this sort of seems like it's going down the same road as liquor licenses, will this create a problem in some towns that have like a limited number of liquor licenses? Will this create will the cannabis license be able to be exchanged, or does it have to go back to the state? You know what I'm saying? Because some liquor license places can sell their liquor license if they close. Will that happen with the marijuana? No or yes?
All right. We'll now predict the future. My sense is that in the liquor field, when somebody wants to buy a liquor license, they're not actually buying the license. They're buying the right to apply for a new license to the exclusion of any other applicant. And I would assume that that's basically what we have here. But I would be surprised. Maybe the industry will develop in a different way. But I would be surprised that many towns will go down the route of saying we're going to allow marijuana facilities, but we're only going to allow 2 of them. I think it's much more likely they're either going to say none at all, or no retail, but we'll allow other kinds of things, or they're just not going to try to limit them in that way. That's what I would expect, but I'm just predicting the future, and you're as good at predicting the future as I am. What do we have over here?
So if you wanted a zoning bylaw that allowed retail in certain zones and not in other zones, so you allow it in 3 and not in 3, would you have to go through this process?
No.
If you're okay, so if you're allowing it specifically, you wouldn't have to go through the
So-
ballot question.
So just like if the default is a retail establishment is allowed in a retail zone, if you wanted to adopt a bylaw that says a retail establishment is allowed in a retail zone, that would be perfectly fine. You don't have to go through this mess. This is only for the 3 kinds of restrictions that I mentioned before, that limit the number or ban either everything or certain kinds of facilities.
Okay, thank you.
Okay? Over here?
Yes, so far you've talked about zoning bylaws.
Yes.
Westboro and some other towns are doing a ballot,
Yes.
a general bylaw, and a
Yes.
zoning bylaw.
Yes.
Is there any insight into?
And
why
one of the
that
towns I represented did a special act on top of that. So.
Is there any insight
So, well, to me, yeah, this raises a question that we spend some time with, is when you're drafting a bylaw, should it be a general bylaw, should it be a zoning bylaw? My view of it is if we're regulating land or use, then it's supposed to be a zoning bylaw. If you're just regulating number, then it probably is going to be a general bylaw. And so if you want to ban retail establishments, for example, and limit the number of growing facilities to 2, you might end up doing both. And in Reading, where we went the step further and did a special act, we threw up our hands and said, we don't know what we're doing, so the best thing to do is to get a special act to ratify what we did. And then, but we probably don't have to do that again. Okay. Who's got the mic? There you go.
I have a question about edibles. You need a
Okay.
permit to grow it and to sell to dispensaries, but my friend owns a bakery, and he's curious about making edibles to sell to the dispensaries. Do you have to have a special permit for that?
Yes, that would be a manufacturing license.
Okay. And that's limited in the towns, per town?
I don't know of any town that has tried to focus on those kind of facilities. There are a few towns, we'll get to that. There are a few towns that have banned all facilities of all types. I would have expected that there would be some towns that would be interested in banning just retail establishments and not growing facilities or manufacturing facilities, but none of them have shown up yet, so maybe we won't ever see that. So your particular town might be the first if that's the road they're going to go down to. Okay, what do we have over here? Okay.
Just to get back to that zoning question real quick.
Okay.
If we have the retail, manufacturing, and testing general categories in our ordinance, would
Yes.
it be improper to create a specific new category for marijuana
No, it wouldn't be. It would not be improper. It would be totally appropriate.
and to then require maybe a special permit and
Sure.
limit specific zones?
Sure, there's certainly lots of, for example, retail districts that have, here's the all kinds of retail establishments that are permitted by right, and then here's the ones that are permitted by special permit. You certainly could do that,
Okay.
all right? Okay.
We're an agricultural community.
Where are we?
here.
Oh, there you are,
We're an
okay.
agricultural community.
Yes?
And one of our marijuana cultivating facilities came before us, and they wanted to do hydroponics.
Okay.
So is that considered agricultural? And I have one other question, too, that I wanted to ask. How is that person that's a registered qualifying patient going to get to the meetings?
All right, I definitely don't know the answer to the second question. Uber. Okay. But with respect to the first one, the statutory language talks about cultivation facilities. And so I would say hydroponics qualifies as a cultivation facility. It still doesn't qualify as agriculture as that term is defined in 40A. Okay? We done? Oh, okay. Well, wait a minute. You have to talk to the into the microphone.
Is there a distinction between the medical marijuana cultivation in that it has to be organic versus the recreational cultivation?
Yes. the regulations governing, well, we think so, I guess is a better
And
answer.
how do
because-
towns-
Because the regulations that the DPH adopted, which probably will carry over to the CCC for medical marijuana facilities, require the use of organic cultivation methods. We obviously don't know what the CCC regulations for retail will look like, whether they will make it the same or they'll make it different. But they certainly can make it different because there will be two sets of regulations.
And how do the towns, how would that sort of play out in town when you're putting a
How would-
bylaw before the town? How would they know what?
Well, keep in mind that
conditions
those requirements are state requirements. They will be enforced by the state. So the town can duplicate those requirements if it wants in its local zoning and then enforce them through the building inspector. Might want to speak to your building inspector whether he's willing to do that. But or you can just take that we, at the local level, we will just assume that there will be compliance with state law. We certainly do that in lots of other circumstances. So that's certainly a permissible way of dealing with it too.
Under the limit of marijuana retailers, it said here to fewer than 20% of the number of package store licenses.
Yes.
Is that something that the state wants to have in their state thing? Because a lot of small towns where you have, say, 2 package stores.
Yep.
20% of two is
0.4?
Is zero.
Yeah.
So,
Well,
so what is this?
I think you'll probably give you 1 in
Okay.
that circumstance. But, well, no, I mean, because this is about if you want to make it fewer than 20%. So if, in effect, you'd be saying it has to be 0. If you limit it to 1, you're more than 20%, so then you're okay.
So this is just example language here. Not a
No, this is the language that would trigger the requirement for a ballot question. So
Okay.
if you do something that's less stringent than that, then you don't need to have the ballot question.
Okay. Thank you.
Okay? All right. Okay, so where are we? So I read on somebody's website that there were 20 towns that have adopted total bans. So there might be. But if you go to the AG's website where they approve these things, there's only 6. So there's somewhere between 6 and 20. These are total bans. These were bans that were adopted under the old system. So they all had some form of vote of the voters, not standardized language. The one that I was involved in was Reading. The vote took place prior to town meeting, and the ballot question said, shall town meeting be authorized to adopt a total ban on, and listed the different kinds of facilities. So it was clearly designed to authorize the town meeting to act if the town meeting decided to act, which it ultimately did. We have representative town meeting in Reading. So it seemed to me that you can't say the town meeting vote in and of itself constituted a vote of the voters. We talked about that in January. So that's what happened in Reading. Most of the other ballot questions were written as if the voters were actually banning it by voting on that day, even though they then had town meeting votes beyond that. So I thought mine was better, but in any case, it doesn't matter because that's not the way we're going to do it anymore. What most towns did, though, was punt. So as of yesterday, this is the list of towns that have adopted zoning moratoriums. So if you were here in January, you might have heard me say that a a moratorium is a pretty good idea regardless of whether you ultimately want to permit marijuana facilities or you want to prohibit them. And the reason a zoning moratorium is a good idea is that you are taking a big chance if you try to draft a zoning bylaw or zoning ordinance today that will govern this, because you don't know what terminology is going to appear in the state regulations. Well, how they're going to name the facilities, how they're going to classify the facilities, and whatever. You will therefore be writing something that almost certainly will conflict in some way with the state regulations. Now, that doesn't mean it'll be invalid. It just means it's going to be really hard to interpret. If you define terms differently from the way the state regulations do. So everyone is well advised to sit tight and wait until those regulations are out, so that when you're writing your zoning provisions, you're writing something that is consistent and uses the same terminology. And it will just be so much easier to administer, so much easier to interpret, and it will keep me out of court, having to try to argue about how to enforce these things. Now, that said, the best time to do a moratorium has passed. The best time to do a moratorium would have been last spring. I checked with the Attorney General's office. They are approving moratoriums that go until the end of 2018, but not any that are. They have disapproved 3 that tried to go longer. So remember that the regulations are coming out on March 15th. Now, presumably, we will have some clue what those regulations look like before they're actually finalized. You know, they'll have a draft, and there'll be public comment and whatever, and maybe we'll know a little bit before March 15th. But that's not real convenient for getting a zoning bylaw on the town meeting warrant to happen in April or May, when most town meetings are. Remember that since it's zoning, it has to go through a hearing process. It takes a while. Plus, getting it on the ballot 35 days before the town election. So, it seems to me that most towns are not going to be ready to write their zoning bylaws next spring, and I have argued to the Attorney General, so far unsuccessfully, but I will be proven right, that moratoriums should be allowed to be longer. At some point, if I'm lucky, my argument will prevail, and you won't all be put under this kind of duress. The only other, so if I were in most small towns, they just do town meetings once a year. They don't really like to do specials, and that means that you've got, even if you have adopted a moratorium, the most you can do is to get your regulations, your zoning bylaw in place this coming spring, and you will not be ready to do it. So, okay, go ahead.
Could you speak to the nexus between medical marijuana facilities and the recreational in regards to moratorium? Because it seems to me that the law has a provision that if you have a medical marijuana facility that can convert into a recreational facility, or can allow that.
Yes. Okay, so part of the answer is at the bottom of this slide. A moratorium is not a prohibition. And why is it not a prohibition? Because it doesn't last very long. And that's the reason the Attorney General doesn't like to approve moratoriums that are very long, and that's why they're holding out on us so far. There is a provision that allows medical marijuana facilities to be converted, to be licensed, and in the old version they got to be first in line, to be licensed as general purpose marijuana facilities. And my understanding is that some will probably want to do that. Once they become a general purpose facility, or once they try to become, then they are going to be regulated under as a retail establishment or as a commercial establishment, just the way somebody who's not converted. So they would be subject to the moratorium. That doesn't mean that they have to go out of business, because they're already permitted as a medical facility, but they won't be able to convert during the time of the moratorium. Okay?
I just want to be clear, when your slide talked about the limits, is this for medical and recreational, or recreational only?
These are only, so I try not to use the word recreational, but I sometimes fall into it. But this applies only to commercial establishments, these limits. We have currently, most towns have zoning bylaws already in place that allow medical facilities, and those bylaws, no, not out here, huh? Well, Stockbridge has one. So most facilities in other parts of the state, shall we say, most cities and towns already have a provision that authorizes medical marijuana facilities in some kind of a zoning district.
Can I phrase that a different way?
Okay.
If out here we don't have any for medical,
you don't have anything at all,
or commercial,
okay,
can this process be applied to both medical and recreational?
So this process,
The one you just described,
this
the
process
ballot and
is intended to apply only to the commercial. There is no requirement. There is no requirement to go through this for a medical marijuana facility. Understand, you may not prohibit medical marijuana facilities. Okay, so it's not just that you can't go through this process, it's you can't do it. All right? All right. Okay. So now comes the fun part, on-premises consumption. So on-premises consumption is the gold standard of a marijuana facility, because anybody who's been to Amsterdam knows you can go and to cafes and enjoy your brownies and your smokes right there. There is a special process that existed under question 4, and it was unchanged. It allows on-premises consumption to be permitted by a ballot vote, but it has to happen at a biennial state election. So that's every 2 years in November. And it can only get on the ballot, not the usual way, where a board of selectmen can just put something on the ballot. It requires a petition of 10% of the voters of the city or town. So it's going to be hard. But I imagine there will be places that make this, that will go through that, and that should make the election in November of 2018 even more interesting. Okay, so the license process is almost the same under the new law as under the old. You submit your application to the CCC. Remember, they said they will start taking applications next year in April. The CCC sends the application to the municipality, and the municipality has 90 days to object. What's a little different when I say to object, this is not in the medical marijuana world. The licensing process requires a letter from the Board of Selectmen saying we don't oppose. This requires you to say, actually, this facility would be prohibited at this location under our local zoning. So that's a different form of objection. And one thing that they added was that it actually has to be in place. So given the timing of this, I think there's going to be some towns that are halfway through the process. They've gone to the ballot, but they haven't gone to town meeting, or maybe the other way. They've gone to town meeting and haven't gone through the ballot. And this specifically says if you're not finished, if you haven't gone through the whole prohibition process, you can't object. So it's important for towns that are thinking that they might want to object, they need to keep this little problem in mind. You've got 90 days. If you say nothing, the CCC will assume that the town doesn't object and will go ahead and issue the license. So you need to be aware of it. And I hope one of the questions that will get resolved in regulation is where that notice to the municipality is supposed to go, because it doesn't say in the statute. One of the banes of my existence is notices that went to one town official and nobody else in town knows about it. Who's got the microphone over here? Nobody, we just have hands. Okay.
Well, I agree with your infinite wisdom in that why doesn't the state say, look, let's hold everything back until we get all our laws and regulations written so that if a town or a city wants to write a zoning ordinance, it doesn't conflict, and then you go into court to battle who's right and who's wrong. And then you get in this issue where you haven't done anything yet, so you're trying to work it through, and it takes a long process. And now you've only got 90 days to deny or reject. I mean, it just seems ludicrous.
Okay. So part of the answer to that question, it depends on where you stand on legalization. The legislature, so in most circumstances, not all circumstances, the legislature is very wary about changing a law that was adopted by referendum. That's why, for example, Proposition 2.5 has never been amended because it was passed by referendum, and the legislature, thinks of statutes that are passed by referendum as being of a special status, let's say. The legislature is subject to influence by lobbyists, and the pro-marijuana people were heard loud and clear. And the message they had was, don't mess with the deadlines that are in the statute. We don't want this process slowed down. That message, you want to know why they did it? Because they didn't want to slow down the process. And if that makes you feel like your town is being railroaded, that's not a byproduct, that's the intention. So,
have they decided on application fee?
No.
The state will start accepting applications on 4/1.
Yes.
And this issue of the municipality having time to object or approve, if I'm hearing you correctly, if the municipality has no moratorium or has not changed its zoning bylaws to, say, particularly define recreational marijuana as a special type of retail and only allowed in an overlay district, who is it that responds back? Is it the planning board or whatever organization in town has that? And if you don't have a moratorium, do you have any protection? You have nothing to object to. unless you have zoning bylaws in place, right?
The only question that you are being asked is this facility permitted in your town under your local bylaws or your local city ordinances? So if you have a moratorium, then the answer is no, and you'll communicate that. If you have a special permit process, the answer probably is yes, it is permitted, except they still have to get a special permit. If you have adopted zoning so it's only permitted in some districts and not other districts, then the question is what they're proposing to do in a district where it's allowed or it's not allowed. As far as who is responsible for delivering that information, it would make sense for that answer to appear in regulation, but obviously there are no regulations yet. The statute doesn't say. If they take the lead from the medical marijuana, where they directed that inquiry to the Board of Selectmen or to the mayor, I'm guessing they'll expect the answer to come from the Board of Selectmen or the mayor. I don't think it's very likely that, say, the planning board is going to be in the spot of having to make that judgment. Okay.
So going back to the question of a ban, so for a town that's voted yes on question 4,
yes,
what would trigger the ballot vote and the question at town meeting? Is it only the Board of Selectmen that can put that language on the ballot vote, or can a citizen's petition do it?
A citizen's petition can do it too.
Okay.
The adoption of the, you may be asking a different question from what I was just answering. Are you asking who can put it on the ballot?
Right.
Okay,
I mean,
so,
a citizen's
no,
petition.
a citizen petition can't put it on the ballot.
Because they can put it on town meeting.
Yes,
a town
but
meeting
not on the
warrant.
ballot.
A citizen's petition cannot bring a vote to ban.
That's correct.
That
is correct.
Oh, that's very interesting.
So
Second.
if you've got a Board of Selectmen that does not want to ban it, you're going to be quite stymied. Now, if you have gone to town meeting and 2/3 of the voters in the town meeting have voted to ban it, most, not all, but most boards of selectmen would say, okay, we'll put it on the ballot.
Got it.
But
And question
probably they
2,
wouldn't have to.
if I've understood you, no town can ban medical marijuana in
That's
their...
correct.
Okay.
That's correct. All right. Oh, I'm sorry. Go ahead.
Yes, Mike Lavery Beckett. The current laws for liquor license and so forth the Board of Selectmen can limit either the hours of operation or put stipulations on persons making loud noises and that sort of thing. Is there any sort of legal ground to limit the hours of operation of a retail marijuana facility?
So the answer to that is, as a licensing matter, the licensing is going to happen at the state level, subject to state regulations, which haven't been written yet. It makes perfect sense to me that a license for a retail facility should have limits on hours of operation. But we can only guess what's going to be on those regulations. Hopefully they will make sense. Now, if you have, at the local level, if you've made the citing of a marijuana facility subject to a special permit, then you can impose those conditions as part of the special permit. And here's an example where I'm saying really you need to wait until you see what those regulations are, because special permit granting authority issue a special permit and say hours of operation is noon to midnight, and then the licensing, the CCC says, oh, the hours of operation have to be 10 a.m. to 10 p.m. You're inconsistent. Now, then we got to figure out how to resolve that sort of thing. So that's why I'd like to see what the regulations say before we get into elaborate special permitting processes and what have you. But we're being stampeded.
Thank you.
All right.
I know the legislation isn't written yet, but are they going to have like specific reasons to deny a license, the CCC? Because I know like the two members that we already know are on there were both strong opponents of legalization. So, but they're going to have specific reasons, like if they don't meet X, Y, and Z, they can't. Then they'll deny the license.
So here's an interesting piece of trivia. Those little Roman numerals that are written in small letters, those are called Romanettes. There are so many Romanettes in this legislation, it makes you cross-eyed. There are a whole lot of things in the legislation that attempt to limit what the regulations can say. It'd be interesting to see whether the remaining members of the CCC, sort of balance those two. It's an interesting thing that those two names came out first, and the other three haven't come out. At the end, you may get a balance, or maybe you won't. I don't know, but it's pretty clear that you can't use the regulatory authority of the CCC to make it so hard to get a license that effectively they're prohibited. Because the statute has a lot of stipulations about what can and cannot be done. Okay, so in general terms, to get a license, you have to be in compliance with the state regulations. Chapter 94G is the statute. Whatever local restrictions may apply. The application fee, we don't know what it is, but it'll have to be paid. The property can't be within 500 feet of the school, and no felons need apply. Now, it turns out, this version of it, not all felons are treated the same. If your felony involves the sale of marijuana, then they're going to let you go, as long as you didn't sell to minors. Okay? So it's not quite no felons anymore. They're going to let some felons in. All right. Now, in exchange for your putting up with all of this, the legislature increased your local option tax from a maximum of 2% to a maximum of 3%. We've got a question here.
Yes, I'm not sure if you're going to get to this part yet, so I'll just throw it out there, and if you want to defer it, that's fine. There's this whole issue about what these companies can do with the money they collect, since they can't put it in a bank, how does that, what is it, Bitcoin? Is that what happens? Do they buy artwork? What is the state doing about that part?
I'm not sure the state is actually doing anything about that part. You are correct that the federal banking system cannot be used. It's illegal as a matter of federal law to use the federal banking system to engage in commerce involving marijuana. So marijuana is a cash business, and there are some financial institutions who appear to be willing to implement something like an ATM card that will, so you don't have to carry around buckets of cash, but we need to all be very at least aware that this whole regulatory process sits under a federal regulatory process that completely prohibits all of this. Okay, so this has been, there are functioning medical marijuana facilities, and they are dealing with the cash problem, but this statute doesn't do anything to make it easier. Okay, we got a question here? Yeah, exactly. There's going to be, I assume, really stringent record-keeping requirements. But yes, cash is the least useful mechanism for payment if you're going to try to tax them. So, go ahead. What, oh.
The 3% that the local town gets, can they put it in the bank?
Yes, I think that the answer is yes. This money will be actually collected by the state, and so it'll go to the state, and then the state will give it back to you, we hope. Okay, so in that regard, it will work like the hotel and restaurant tax. It'll go to the state, and then the town will be reimbursed. I guess I don't want to say that puts the state in the money laundering business, but so I won't say that. Okay, so some time ago, like 20 years ago, we started recommending to our client towns that whenever they dealt with a important zoning issue, that they enter into a host community agreement with developers to make sure that we know what obligations are being promised. This derives from some bad examples that happened in the 70s and 80s, where developers would come before town meeting and promise to do, all these things in order to get town meeting to change the zoning, and then there was some case law that said, yeah, well, you can say anything at town meeting, it doesn't mean it's binding, and it was bad. So we started advising people to enter into host community agreements, and we started off as a sort of lone wolf making that recommendation, but the casino law took the term and made it into statute, and so now in the casino law the word host community agreement exists, and now it exists in the marijuana law as well. So I feel like my baby has been born. So all marijuana establishments, including medical marijuana establishments, will now need to have a host community agreement with the city or town. The statute says that it will stipulate all responsibilities between the host community and the establishment. That's where the community, and then on top of the 3% tax, you can also impose a community impact fee, 3%, up to 3% more. But you can only do it for a period not longer than 5 years, and it's supposed to be tied to the costs incurred by the municipality as a result of the operation of the facility. So if you incur extra police costs, or I don't know what else, public health services costs that you can tie to the existence of this facility, that's what the community impact fee is supposed to be addressing. It appears to us that since the statute requires you to demonstrate that the costs are associated with a facility, that it doesn't really matter. You might as well go for the whole 3%, because you're not going to be able to collect the whole 3% unless you can prove that you can prove that you've incurred those costs. At least after the first year. The other thing that is a little weird here is that it doesn't say that the host community agreement can only be in existence for 5 years, only that the community impact fee can only be in existence for 5 years. We are debating in our office whether, therefore, the right piece of recommendation is to say you should enter into a host community agreement that is no longer than 5 years. At the end of that time, it expires. The facility needs to have a new host community agreement in order to operate legally under its license, and we can impose 5 more years of community impact fees. That seems a little too cute to me, but others in my office are ready to go with that. So we'll see how that, that shakes out when it comes time to actually negotiating them. If I am writing a host community agreement, I'm going to want more than what it says in that statute in there. I'm going to want it to lock down in explicit terms exactly what this establishment is, what its metrics are, how big is it, what does it look like, any metric that we can possibly lock down on it. I will want a specific specification of what mitigations are being offered above and beyond whatever the licensing requires. And I would be looking for offsetting benefits for the town, things that they're willing to do to demonstrate that they're going to be good town citizens. I would want provisions dealing with uncertainty. What happens when they go out of business? What happens if there's a fire? What happens, in various contingencies, and what have you. And then finally, what are we, the town, city or town, promising in return? What is it that, if this is an agreement, there needs to be a promise back and forth, what is known in legal terms as consideration. And so I'd want all that specified in there. None of that's in the statute, but certainly we would advise that to be so. Okay, I almost took these out. We showed these last time. What are the rules governing civil and criminal penalties? They're actually made them a little, because 3 slides wasn't good enough to present it all, they made it a little bit more complicated. So the ones that are outlined in dotted lines are new. The penalties are, in fact, a little bit less than they were before. And I also would like to point out that some of the old penalties were in fact not repealed. The legislature apparently forgot. So the old penalties are in there still, but we assume that their intent is to have the new penalties work for it. So essentially, if you have a CCC license, you're over 21, you can cultivate to your heart's content. If you don't have a license, you can only cultivate at your primary residence. If you're 18 to 21, you have to there is a civil penalty of not to exceed $100, and drug awareness program. The possession is a little bit simpler. It was 1 ounce, now it's 2. And the civil fine is $100 if you are under 21, otherwise it's legal. And for distribution, the one thing that's different is that the gifting of so you can give away marijuana with a license. It's always legal. Without a license, it's legal as long as you stay under an ounce. And there are some penalties for doing gifts, and so those appear on the form. All right. Okay, so that's it. That's it. We're done. We need questions. We've had a lot of questions, but we need to have some more. Over here.
Hello.
Since you have a lot of wisdom, do you have a draft moratorium for the zoning that
Yes.
we could all get from you? I don't know if we'd hire you or something, and we could use the same one for a lot of small towns.
Sure.
Okay.
You don't even have
Figure
to
out how to
hire
do that.
You don't even have to hire me. If you get your email address to me, you see my email. It doesn't have my email address. It just has my website. But if you go to my website, you can connect to me. You can connect to me that way, or you can give it to Tom, and I'm happy to send you the moratorium language that we recommended to our clients.
The subject of host community agreement.
Yes.
Does that apply to cultivation? Does that
Yes.
have to be in place for cultivation as
Yes.
well as
Yes.
all establishments, cultivation included?
Yes.
Okay.
All right.
There was an excellent article in the Berkshire Eagle yesterday by Larry Parnass, who's surely here this evening, on the new Cana Care in Pittsfield. My question is, how concerned are you and us regarding the motivations and qualifications of doctors certified for prescribing medical marijuana?
Well, I'm just a poor country lawyer, and I don't really have the expertise to judge the overall impact of or wisdom of allowing marijuana to be prescribed. I do know, I have a friend who is a physician who said to me that that marijuana is the one substance that when he prescribes it, he can't control what's in it. So every other thing that he prescribes, it specifies just exactly how much of the agent is in there. And he said that causes him concern. He's a physician, so I will pass that along. Okay.
I wanted to ask a follow-up question on
I can't
farming.
see. Oh, there you are. Okay.
You said that, again, we're a farming community. So someone can, cultivating recreational marijuana, I'm going to exclude medical because I know I'm familiar with how that is cultivated. So on recreational marijuana, you need a CCC license
Yes.
to be able to cultivate up to the limits that you just showed us, whether you're going to use it yourself or whether you're going to gift it or you're going to distribute
So if you're talking about cultivation for yourself at your residence, you don't need a license for that.
Okay, so you don't. But if our farmers who wish to grow marijuana for recreational uses for sale by a retail firm, how do they get licensed? Because it's not covered under the right to farm as agriculture.
That's right. They have to get a license from the CCC.
So they have to go through a particular issue.
That's right.
Now, if for some reason a town wanted to particularly limit its retail marijuana establishments, do they also have the ability to limit the number of grower licenses?
Yes. Yes. You can establish limits for each category if that's what you want to do. Over here.
I'm wondering if there's any chance of change on two areas that I see as problems. That's the unresponsiveness of the Board of Selectmen concerning the ballot if they decide to not go with the the will of the town, and also the possibility for a bureaucratic snafu with this licensing within 90 days. Do you see any remedy if problems arise, or any chance that that will get tightened up?
With respect to the recalcitrant Board of Selectmen, none of my selectmen are ever recalcitrant, by the way. But in some hypothetical town where a Board of Selectmen is recalcitrant, I don't see that there is any remedy. The law is pretty clear that only the Board of Selectmen have the ability to put a question on the ballot unless there's a specific provision like there is the one for on-premises consumption, which allows it to be done with 10% of the voters. So apart from amending the statute, I don't see that there's a remedy. As far as the 90 days goes, I don't know that the CCC is going to be sympathetic to this problem, but if they are, I don't see any inherent reason why they can't say that the 90 days can be extended, or doesn't start to run until the selectmen have taken it up at a public meeting, for example. Write a regulation that says the 90 days don't start to run until then, and that would eliminate any problem that arises from the notice having gone astray, for example.
But that's not currently...
Well, there are no regulations yet. But that's the kind of detail that I would expect to see in a regulation.
Thank you.
And that problem could be addressed in a regulation.
Our use table, and I know you don't know our use table by heart, but our use table only allows agriculture as defined by 40A.
Yes.
We don't have a line in our use table that allows other type of agriculture.
Uh-huh.
Does that mean that cultivation of marijuana is not allowed in our town?
Oh, you're not going to get me to say that.
No.
Okay, so many zoning bylaws have a provision that says if it's not listed on the use table, it's not permitted.
It's not allowed, right.
Okay?
We have that.
You have that?
Yes, we have that.
Okay. Many bylaws have a provision that says if it's not specifically listed, it goes by whatever is the closest, the most comparable thing. Presumably you don't have that.
I don't think so. Do we have
Okay. I'm not giving legal advice. You saw. I'm not giving legal advice. Okay. It sounds to me as though it's prohibited.
But there's nothing in the state law that requires, like medical marijuana, there's nothing that requires the town, or that prohibits the town from prohibiting it.
But so it sounds to me as though you're prohibiting one type of thing. Now, this requires that you go through a whole process if you're going to prohibit it. So, I would take the position that any bylaw that was adopted before all of this is still good, and I did in fact take that position in one of my towns because we happily had something in our medical marijuana that said all other kinds of marijuana establishments are prohibited. So. For now, I'm taking the position that that's good because it was perfectly permissible when it was adopted. But if you really want to be safe, you really should go through this process.
Many towns in Berkshire County have adopted a right to farm bylaw.
Yes.
And so when you buy a property, you have to actually be put on notice that it's a right to farm town.
Yes.
Do you think that form needs to be amended if marijuana is legal to grow in the town?
I don't think the form needs to be amended, but you just need to understand that right to farm is a kind of a simplification of the concept that neighbors can't complain about what is going on your property if it's farming. So if it smells bad is the most usual thing. So it doesn't mean, despite its name, that you have the right to farm anywhere. It means that if you are engaged in farming, you can't be the subject of, a nuisance action or something similar that's trying to regulate the side effects of farming. Okay, so marijuana farming doesn't look like farming. It's done inside a warehouse under grow lights. It looks like manufacturing from the outside. So, somebody who is engaged in somebody who's engaged in marijuana cultivation isn't doing, the sorts of things that you normally would look at and say that's what agriculture looks like, which is the reason why they said it's not agriculture. So, I would take the position that cultivation facilities are not covered by a right to farm bylaw as a general proposition. And now I will say the opposite, which is in any specific case it might be, depending on what exactly you've got.
Genius.
Yeah.
If a farmer gets a license and he has to cultivate it indoors, right?
Yes.
Can it be in a glass greenhouse, or does it have to be like in an enclosed building with lights? Can he grow with, the sun? I know the doors have to be secure and things like that.
Okay, so the answer is in two parts. One is I don't think it's possible to do it in a greenhouse type facility, which is the reason that these things are done under grow lights. And I don't think it's possible to do it successfully in a greenhouse type building in Massachusetts. But
what if it was hydroponics?
Let's say it is. Okay.
What if it was hydroponics and it was under glass? I don't know.
The second part of my answer is that the regulations will specify exactly what that building needs to look like. And I don't know whether they're going to say that building needs to look like a greenhouse, but the medical marijuana facility license regulations don't contemplate a greenhouse type building. They contemplate a secure building and indoor lights.
So is the law specific that you cannot grow it outside? Fenced in and all that? You have to grow it indoors? I mean, for yields and stuff, I can understand that.
I think the answer is that you have to grow indoors, yes. I believe that is true. One more down here. Okay.
Can a farmer rent out or lease lots on his property for individuals to grow plants of marijuana? And hydroponics is with water and can be in a greenhouse. So can a farmer?
So I don't see any reason why a property owner of any description would be prohibited from leasing out part of his land for a grow facility of some sort. That doesn't mean that just because they can issue they enter into a lease doesn't mean that that person get a license. And so it will depend on what the licensing
Individual.
But the individual is only for growing and their principal residence. So are they leasing it out for the person to live on this place too? So, all right. Okay, well, thank you very much. Sorry, one more.
Okay, one more person with two questions. The distinction as to whether or not you can grow indoors or outdoors is, I think, very important, particularly out here in Western Mass, where there Can you hear? Sorry, I'll speak up.
Okay, that's better.
Inside or outside is very important distinction. And the
Yes.
medical regs, I think, or law says it has to be inside.
Yes.
So are you confirming for a commercial operation it would also have to be inside? And not just based on economical, but based on the actual law?
So I am not confirming it. I am
Okay.
saying that I believe that you can expect that that's what the regulations
That's
will
where it's going to
require.
go. It doesn't say it yet. Okay. Consumption on premises licenses.
Yes.
If I understand that, nothing will be voted on until November of 2018.
That's correct. That's
And
the first
it would
opportunity.
take a petition of a of a town
Yes.
or city in advance of that in order to make that happen.
Yes.
Otherwise,
So
they are not allowed.
This is the opposite of the recalcitrant Board of Selectmen. The eager Board of Selectmen cannot put it on the ballot. It has to come from the 10%, petition of 10% of the voters.
But otherwise not allowed. Sure.
That's right.
Okay. Thank you. Common misconception, I think, what I've found, people out in Western Mass where there are farmers think of it as an agricultural business. And if it has to be done inside, they need to be thinking that way.
That's right.
Right. So
I think
thank
that's
you.
fair. I think that's fair. I'm done. So thank you very much for your patience and your time.
Good job.